Welcome to Module number 8. How does the privacy rule apply to you? If you are having trouble accessing any of these modules, contact the Chief Privacy Officer at privacy@uvm.edu or call the Office of Audit, Compliance, and Privacy Services at 802-656-3086. Otherwise, let's begin. In order to know how the privacy rule applies to you and to your research, it is important to dive a bit further into the different categories that could apply to you. The first would be to determine whether you are considered a covered entity and thus required to comply with the privacy rule. Covered entities are defined in the HIPAA rules as health plans, healthcare clearinghouses, and healthcare providers who electronically transmit any health information in connected with transactions for which the Department of Health and Human Services has adopted standards. Generally, these transactions concern billing and payment for services or insurance coverage. For example, hospitals, academic medical centers, physicians, and other healthcare providers who electronically transmit claims transaction information directly or through an intermediary to a health plan are covered entities. Covered entities can be institutions, organizations, or persons. If you are an employee of a covered entity, you are required to comply with the privacy rule. Researchers are considered covered entities if, in addition to their research, they are also healthcare providers who electronically transmit health information in connection with any transaction for which the Department of Health and Human Services has adopted a standard. For example, physicians who conduct clinical studies or administer experimental therapeutics to participants during the course of a study must comply with the privacy rule if they meet the HIPAA definition of a covered entity. Researchers are also considered covered entities if they work in a covered component of an organization that is not by itself a HIPAA-covered entity. The privacy rule refers to these as hybrid entities. The privacy rule defines a hybrid entity as a single legal entity that is also a covered entity. It performs business activities that include both covered and non-covered functions, and designates its healthcare components as required under the privacy rule. If a covered entity is a hybrid entity, the privacy rule generally applies only to its designated healthcare components. However, non-healthcare components of a hybrid entity may be affected because the healthcare component is limited in how it can share PHI with the non-healthcare component. The covered entity also retains certain oversight, compliance, and enforcement responsibilities. The University of Vermont is a hybrid entity. While UVM only has a small number of covered components, those areas are required to comply with the privacy rule. As specified in a previous module, the University of Vermont Health Network affiliate sites and UVM Medical Center are separate and distinct organizations which are covered entities. Speaking for the university, most of the privacy rule's requirements will only apply to the components designated by UVM, and the privacy rule would govern only the PHI created, received, or maintained by or on behalf of these components. A list of UVM's covered components can be found by visiting www.uvm.edu/compliance/HIPAA_information. There is detailed guidance on what constitutes a covered component and what does not. If you are uncertain and you are not listed under the covered components, contact the Chief Privacy Officer at privacy@uvm.edu. Lastly, the privacy rule protects individually identifiable health information when it is created or maintained by a person or entity conducting certain functions on behalf of a covered entity. These individuals or entities are referred to as business associates. The privacy rule defines a business associate as a person or entity who, on behalf of a covered entity, performs or assists in the performance of a function or activity involving the use or disclosure of individually identifiable health information. Examples include data analysis, claims processing or administration, utilization review, and quality assurance reviews, as well as any other function or activity regulated by HIPAA. Business associates are also persons or entities performing legal, actuarial, accounting, consulting, data aggregation, management, administrative, accreditation, or financial services to or for a covered entity where performing those services involves the use or disclosure of PHI. Because the HIPAA administrative simplification rules do not directly regulate research activities, the privacy rule does not require a researcher or a research sponsor to become a business associate of a covered entity for research purposes. However, a covered entity may engage business associates to assist in a host of functions that researchers may perform. Examples include de-identifying PHI, preparing limited data sets, or performing data aggregation. The privacy rule requires a covered entity to enter into a written contract with its business associates. These are commonly referred to as business associate agreements, or BAAs. Generally, a covered entity may, for the purposes permitted by the privacy rule and specified in its BAA, disclose PHI to that business associate and allow the business associate to use, create, or receive PHI on its behalf. Before the covered entity discloses the PHI to the business associate, the covered entity must obtain satisfactory assurances, generally in the form of a BAA, that the business associate will appropriately safeguard the information. With a few limited exceptions, the BAA may not authorize the business associate to use or further disclose the PHI in a manner that would violate the privacy rule if the use or disclosure were done directly by the covered entity. While research does not require a business associate agreement, it is not uncommon for covered entities to require a BAA or similar agreement to be executed prior to allowing the researcher to use, create, or receive their PHI. The determination of whether an individual researcher must comply with the privacy rule is a fact-sensitive, individualized determination. The answer to this question may depend on many factors, including but not limited to where the researcher is employed, whether the research is through the university or through another entity such as a hospital or other covered entity, and how the entity with which a researcher has a relationship is organized. If you have questions on determining your status under the privacy rule, contact the Chief Privacy Officer at the covered entity or at the university. UVM's Chief Privacy Officer can be reached at privacy@uvm.edu. You have now reached the end of module number 8. If you are taking this training as part of a requirement, you will have to answer questions in order to move on. Next up is module number 9. What do you need to protect under the privacy rule?